friends, welcome back. In the last session, we learnt about Order 9 of CPC, which speaks about the appearance of the parties and consequence of non-appearance of the parties. Okay, friends, let us say the plaintiff, the defendant filed his written statement and documents. All the parties filed their documents along with their pleadings, and the next step is Order 10, Rule 1A. Actually, Order 10 deals with the examination of parties by the court after completion of the pleadings. The court has to examine the plaintiff and the defendants regarding their cases. In this Order 10, Rule 1A says that after completion of the pleadings and after recording the admissions and denials of the parties, the court shall direct the parties to opt one of the ADR, alternative dispute resolution modes, as mentioned in section 89 of CPC. Okay, friends, and the court shall direct the parties to opt one of the forums, as mentioned in section 89, subsection 1A, clauses A, B, C, D: arbitration, conciliation, lok adalat, or mediation. Okay, friends, and the court shall fix a date directing the parties to appear before such forum. And Rule 1B says that the party shall appear before the forum, like arbitration, arbitrator, conciliator, or lok adalat, or mediation, etc. Okay, friends, and Rule 1C says that if the forum which was directed by the civil court to settle the matter between the parties of the suit feels that there are no elements of settlement and it is not proper for adjudication by the forum shall refer the matter back to the civil court, fixing a date, directing the parties to appear before the civil court. Okay, friends, these are the three rules mentioned in Order 10 of CPC. Okay, friends, section 89 says that if the court comes to a conclusion that there are elements of settlement between the parties, the court may direct the parties to choose one of these ADR modes, that is alternate dispute resolution modes, namely the arbitration, conciliation, lok adalat, or mediation. Okay, friends, and this subsection 2 says that so far as the arbitration and conciliation are concerned, the provisions of Arbitration and Conciliation Act 1966 are applicable. And so far as the lok adalat is concerned, the provisions of the Legal Services Authorities Act 1989 are applicable. And so far as the mediation is concerned, the rules of mediation are applicable. And by the reinsertion of section 89 of CPC, the mediation rules were not framed, and subsequently mediation rules have been framed. Okay, friends, these are the settlement of disputes outside the court as contemplated under section 89, and the procedure is contemplated in Order 10, Rules 1A, 1B, and 1C. Okay, friends. Okay. Next, we directly go to the settlement of issues by the court, basing on the pleadings of the parties. Friends, before that, the Order 10 of CPC deals with examination of parties by the court. Order 11 deals with the discovery inspection, and Order 12 deals with the admissions made by the parties, and Order 13 deals with the production, impounding, and return of documents. Because because the parties in their pleadings themselves either admit the claims of opposite party or deny the claims of the opposite party, or the pleadings or the documents. Therefore, nowadays the advocates are not depending much on the provisions of these orders. Therefore, I am not interested to discuss these provisions. If any one of you is interested, please comment and I will discuss these provisions also. Okay, friends. Okay, see you in the next video.